It's important for lawyers to understand that law firm size equates to law firm risk. And the smaller the firm, the more dangerous the practice.
Having your employee bring something to you internally and being able to resolve it, look into it, take corrective action for real is so much better than first learning about it when they filed an EEOC complaint.
Employees, whether they're lawyers or not, social media use is key, and you have to, not doing it is not an option. You can't just assume people are using their social media responsibly. I would say assume they're not.
The law firm clientele that we see in our practice, the number of mental health requests for accommodations in the last couple of years has skyrocketed.
Welcome, and thank you for joining us for another Justia webinar. My name is Lavinia, and I will be the moderator for today. Now, to kick things off, I wanted to introduce our speakers, Jennie Woltz, Benjamin Folkinshteyn, and Jeffrey Cunningham. Jennie Woltz has made smart, compassionate employment and labor law solutions the focus of her legal career. Before co-founding WFPC, Jennie has honed her legal expertise in private legal practice at some of New York's most prestigious law firms. Jennie has also worked in a dual legal and HR role at one of NYC's largest children's charities. She currently advises clients in all areas of employment and labor law, and when necessary, advocates on their behalf in adversary proceedings. With her help, business owners and HR leaders identify, avoid, or mitigate employment-related risks. Benjamin, or Ben Folkinshteyn, has broad experience in domestic and international dispute resolution, including contract and tort matters, corporate governance litigation, as well as insurance litigation and arbitration. He regularly counsels clients on litigation avoidance strategies and legal and business risk assessment. Jeffrey Cunningham actively defends lawyers and acts as outside general counsel to small and mid-sized law firms across the United States, while also serving as his firm's general counsel. Jeff defends industry professionals in a wide range of professional liability, ethics, and professional disciplinary matters. With an emphasis on simple systems of risk management, Jeff brings a holistic approach of protecting clients before problems occur. Now, this webinar will be approximately 1 hour. If you have any questions that come up during that presentation, please feel free to submit them at the Q&A button at the control panel on the bottom of your screen. Now, without further ado, here are Jennie, Ben, and Jeffrey to discuss lawyers as employers answering to a higher authority.
Thank you so much. Great intro.
But welcome to Lawyers as Employers Answering to a Higher Authority. Ben, Jennie, Jeff, thank you for the great intro, Lavinia. And, I shouldn't be the one seated over here to be the IT man, but I am. So you started a law firm. Congratulations. Now what? My practice revolves around defending lawyers and law firms and working on risk management before there's problems. And I think so many lawyers forget, even sometimes employment lawyers, forget that law firms are a small business and lawyers are therefore employers. And there's a host of risks that come along with that. And I see so many lawyers kind of overlook that, make that mistake. And then maybe as they grow, they get to the 10 or the 15 employee threshold, and then they realize, oh, wait a minute, we actually need some help here. But something to keep in mind, regardless of your size or practice area, if you have one employee, then you are an employer, and all the risks and rewards that come along with that need to be thought about. So we're going to try to make this interactive as best we can. In the poll, if you could just drop, I see we have a lot of participants here, but if you can drop
in the chat.
In the chat, what did I say? In the
poll.
In the poll, yeah, in the chat. No, that's important. So just in the chat, if you can drop, the size of your firm, we'll give it a second.
While we're waiting for people to respond, I'm going to piggyback off of something Jeff just said about the size of your law firm. Ben and I are very lucky to have numerous law firms as clients as well, as regular businesses, and law firms face really interesting employment issues. It's very different having a workforce full of service and information providers as opposed to helping employers with more physical or factory kind of jobs. But what Jeff said is 100% true, that even starting with one employee, you start becoming obligated under the labor and employment laws in many different jurisdictions, and the risk continues to increase in all kinds of coverage.
So
Who are we getting right?
Yeah, we're getting some great answers. So there we go. So we've got some small firms, 1, 5 to 10, 6, 10,000 employees, which is yeah, that's awesome. If you guys need a general counsel, let me know. Let me just see. All right. So, bearing in mind that I think it's important for lawyers to understand that law firm size equates to law firm risk. And the smaller the firm, the more dangerous the practice. There's tons of reasons for that, and I'm happy to chat forever about that, as these guys know. But a third of all legal malclaims are against solo practitioners. 72% of all legal malclaims are against lawyers of firms of 10 lawyers or less. And so it's really important to understand that the smaller your firm, the riskier your firm. Now, your practice area is also involved in that calculus. Those are the two big factors. But I think your firm size is really important. Now, the ABA tracks that information based on lawyers, not staff. So even the ABA sort of ignores and forgets this reality of law firms as employers. So it's important to think about. But the basic correlation is you should have a 1-to-1, 1-to-2 lawyers to staff.
Jeff, what I will share with that, though, is you might be right on an ethics standpoint in terms of risk with smaller employees.
Oh, yeah. Okay.
But there's two reasons why having a larger staffs actually increases your risk for employment law related liability. And the first reason for that is that, as many of you probably know, there are different laws which come into play and you become covered under the larger you go, up to, starting at, for most federal laws, I mentioned already, state and city can be as little as 1. Federal laws starting with 15 or 20, 50, you got different liability under the FMLA. 100, you've got it, under federal WARN. So your risk increases in terms of, employment related risk, because you're just covered under more laws. So there's more theories of liability. And the second reason is because employment litigation is rife for class actions. So if you have a problem structurally with your hiring practices that are against the law, you're going to have it across the board. And then you'll increase class action risk liability in the employment context. So to make that distinction.
Yeah, great point. So it's risky if you're small, it's risky if you're big.
And we should put on a graph for the next presentation to actually see the inverse.
Yeah, where the danger zone is. I like that idea. So today we're going to talk about employment discrimination and legal ethics. Social media use, which, I think is just ever expanding. And I'm a huge LinkedIn guy, so I always like to listen when I talk about this stuff.
Everyone should follow him.
Oh, yeah, please follow me on LinkedIn. And confidentiality. And I think that's a really important nuance to your social media use as an organization, but also your employees, your staff, your team's social media use. And then culture, mental health, and substance abuse. As I'll talk about, our profession has just terrible mental health and wellness statistics. They're like 3 times worse than the average American, and the average American stats aren't exactly good. So I think starting to address that from a law firm standpoint, from an employer standpoint, I think is absolutely key. I think it is risk management to promote wellness of your people, your lawyers, your staff, everybody. And I think that's just so important and kind of easily overlooked. All right.
Okay, so let's talk about discrimination in law firms. First off, I bet it will come as no surprise to anybody who's on this call that discrimination is still well and alive within all areas of our country, and including in law firms. We've continued to see over the last couple of years lawsuits against law firms alleging discrimination in a whole bunch of different ways. We've listed a couple of the most major ones: gender, pregnancy and caregiver discrimination, age discrimination, race discrimination, disability discrimination, and retaliation. But there are more, depending on your state and local laws. A lot of states and local laws protect other kinds of protected classes. Some of you might be aware, just about a year or two ago, New York City included height and weight discrimination, for instance. So it's important not only for your law firm to know what the protected classes are, but also to really be thinking about how to not only prevent and avoid discrimination within your law firms, and that's looking both at individual treatment of employees as well as systems, processes, and culture, which might contribute to a disparate impact. A really common one, which of course many people have tried to make claims about in the past to some degree, is kind of the always on culture, billable hour requirements. These kinds of things, if not managed properly, can have huge disparate impacts on, primarily women, caregivers, anyone who has certain kinds of disabilities, and those things can contribute to overall problems within your workplace. Mind going to the next slide? Were you going to say something?
I was just going to chime in that this week I've been working on a gender discrimination issue for a law firm, and they have really foolish things in emails written about the likelihood of female associates becoming pregnant, becoming stay-at-home mothers, and leaving the firm. But it's actually an issue with a young father attorney who took paternity leave and was really facing, a discrimination, I think, on that front. Like, sort of like they were upset, like they had a paternity leave policy and they were really upset that he used it and no one else had really used it before. And then it's turning out that, their maternity leave communications aren't exactly good either. So it's just, something that cropped up last week or this week, and we're working through it. I think we'll be able to resolve it. But just a reminder that, like, while the firm is working through legitimate issues, like what's our parental leave policy going to be, not everyone should comment in writing, maybe the first thought that comes into their head. Maybe they should step back and say, well, if this was in a deposition, would I want my email to read quite this way? You can get the same point across, I think, unless it's truly discriminatory. You can get the same point across in a polite and professional way. So I think that's important to keep.
And we will return to the topic when we talk about social media.
Social media, exactly, yeah.
Absolutely. What Jeff just said, sometimes I think lawyers, because we're so used to thinking that everything we write is privileged, that we sometimes forget that not everything we write is actually privileged, especially if we are going to be the defendants in a future discrimination lawsuit. So, how does discrimination present itself? I kind of alluded to this when we were on the last screen. Obviously, advancement decisions, performance, partnership decisions, exclusion from business development opportunities, these kind of glass ceiling claims. I remember when I was once a younger associate, there was a huge debate over whether having a golf outing at our firm was it seemed like a very neutral way of having a client development meeting, but the truth was that it appealed a lot to the male partners, and a lot of the female associates and partners in the firm, weren't golf pros, hadn't done that, and so there was a lot of discussion about how to make even our social engagements and client development things more inclusive to people of both genders, and not to mention the social class implications, of course, of a golf outing. Billable hour expectations and leave policies, we mentioned that a little bit before, can have a real disparate impact on people who need to take time off, or who are, billable hour policies in general don't necessarily always reward efficiency or getting the right answer. They more recognize availability. I'm not saying there's anything wrong with billable hour requirements. I'm just saying be mindful of this. Phasing out
Topic, Jeff. I know you're not.
Phasing out of older workers still happens, across the board. Many law firms have effectively mitigated that through, very lawful retirement procedures and policies. Disparate assignments, tokenism, lack of mentorship, or hostile work environments certainly still happen in law firms. One of the interesting things that I've started to see in our practice when people come to us is almost the reverse of lack of mentorship, is putting extra burdens on female partners to mentor their younger associates. And one of the concerns there is, I've got so many female associates that I'm expected to mentor, and my male my male counterparts don't have as many, and I'm being asked to be a role model to all these women, but like they don't have to do as much, and now I've got all these extra administrative hours that I'm now being burdened with. So it's very interesting that sometimes these really well-intentioned efforts to promote equity and to help lift people up can have these strange disparate impacts when you really look at how they're affecting your workforce. Failure to accommodate visible and invisible disabilities. We're going to talk a little bit more about disability discrimination a little later on. But these are some of the ways that we see discrimination presenting itself. It's pretty rare in a law firm professional environment for there to be specific negative direct evidence of discrimination. No one is going around saying negative things about minorities, but the prevalence of the culture tends to be the areas of concern.
And I won't mention the firm's name, but there is a caveat to that. There was an employment law firm 2 years ago now who had an incredible trove of I mean, it was a very large law firm. And this was leadership in the employment practice group. And, they, again, I think this idea that our emails are somehow sacrosanct, they, managed to insult, I think, every potential possible class and ethnicity and group you could come up with in their emails, including the judiciary. So it happens, and it happens to lawyers who certainly know better. But yeah, I think overt, discrimination or evidence of it is relatively rare. So I did want to touch on the phase out of older workers, and that sort of cuts the other way oftentimes in the partnership side, right? Especially the founding partner side, where you have, and I had one client who was 102 and is still practicing. He passed away a few years ago, but oftentimes lawyers are very resistant to giving up their partnership interest, and it can sometimes be it can sometimes work, but it also can be a real big problem. And even, correct me if I'm wrong here, but even trying to push out someone who is a lawyer and has lots of power and is a partner and is even an owner can be problematic if you're really just doing it based on the fact that, oh, he's an old guy, so he's got to go. So I think building mandatory retirement into the partnership agreement at the outset is really helpful, because it's before everybody's of age and everybody agrees while they're being reasonable and getting along. So something to consider.
Definitely. So there's a couple of best practices. Obviously, we could spend all day, every day, for numerous days talking about discrimination and ways to prevent it. But there's a couple of best practices that I hope that all law firms have, and it includes our own. We're a small, 2-person practice. We just hired an assistant coach as well. We're now 3 people, which is great. Having handbooks and clear policies. Handbooks serve so many functions. For a whole bunch of different reasons, but a really big one that we look for oftentimes is legal compliance. There are a whole bunch of different notifications and kind of policies that you actually need to distribute or notify your employees about, based both to establish affirmative compliance and oftentimes a defense to certain kinds of claims. So having handbooks that are vetted for legal compliance is a must. It also, the other reason, which going back to something I said earlier, is that it can help reduce class action risk, right? So if you have a handbook policy that's legal and compliant, but you make a mistake on one person, much less likely that that's going to be transformed into a class action. Whereas if you have an incorrect policy that you're clearly applying to everybody, or if you have no policy at all and it's up for debate. So very important to have clear handbook policies that are updated for legal compliance. We recommend once a year. Second, providing avenue for complaints in your handbooks in ways that are meaningful, that employees can actually follow and can do so without fear of retaliation is also your best way. Having your employee bring something to you internally and being able to resolve it, look into it, take corrective action for real is so much better than first learning about it when they filed an EEOC complaint. And having systems and processes.
Let's jump in. Sorry.
Yes, please.
But both, the handbook policy approach is also from the professional liability, the ethics standpoint, super important as well. And, there's so much overlap in the handbook between the employment stuff and the professional liability ethics stuff. But if there's a problem with supervision, really any ethics complaint, if you're able to turn around and say, yes, we have a cyber use policy, here it is, bar, or yes, of course, we have a confidentiality provision in our handbook, here it is, court. It just sets the conversation in responding to any problem so much better than if you're like, of course, everybody knew we had to keep confidences because we're lawyers. That looks so much like an afterthought to the bar. If you're able to point to this handbook that's been out for years, that you've trained your people on, it really does go a long way in resolving issues easier. And then that avenue for complaints, I think, is absolutely key, because it's not just employment complaints, but when mistakes happen, when people have questions or concerns about, and it doesn't have to be a case specific. It could be a billing practices question or a technology concern about confidentiality or something. That avenue allows for firm leadership to get those complaints before they blow up and become a problem that you learn about in some other way. So I think both of those points really, really provide risk management across the board, not just from the employment standpoint.
But also, just to address something, just to tack on something, it's not only lawyers that have certain obligations under the ethical provisions. If lawyers might have some expectation that they understand, but we also make sure that the staff understands that they have the same they have the same obligations because they are working in this environment.
Right. Exactly.
Yeah, that's absolutely. Everything both of you said is totally correct. And continuing on with that, the idea for having systems and processes in place that you can go back to demonstrate that you're treating similar people similarly is so important. And the most fundamental way to show that is to have a policy written in writing. Although, oftentimes the way that things get done in all kinds of employment situations, even if you don't have a written out policy demonstrating that something has been your practice and your course of how you handle things can be hugely valuable when someone claims that they've been treated differently because X, Y, and Z happened. If you can go back and you can show through emails, you can show through other documentation, like, no, this is how we always handle this performance issue, and we handled it the same way, and we've been consistent. That goes a really long way towards fighting discrimination claims. A second building practice, best practices, building block number 2 here would be good internal investigations. So we just talked a little bit about why it's so important to have avenues for your employees to be able to raise potential ethical concerns, potential concerns about discrimination, retaliation, hostile work environment, wage problems, payroll mishaps, all of those things. But so having good internal investigations is also something that is really important. And there are actual federal and state rules, at least in New York and certainly in other jurisdictions, that would require when an employee raises a concern that your business conduct a prompt, thorough, and objective investigation into those practices. And what is prompt, thorough, and objective obviously is going to be super fact specific. But having someone who is at least aware of the urgency of investigations, knows how to do it, and can create a protectable investigative report to demonstrate why the investigation came out the way it did and what steps were taken as a result, can also be hugely valuable in defending claims of discrimination, harassment, retaliation.
And I think, obviously, if you're capable of running those internal investigations, I think that's great from the employment side, from any sort of problem that arises in the firm. But I think outside counsel is really invaluable. It provides the cover of privilege. It provides objectivity, and this relates to the last bullet point here. But it also, if there's a mistake done in the investigation, you can turn to that attorney to make you whole, to fix the damage. I think the Upjohn warning. I'm a big fan of Upjohn warnings all the time. I represent the law firm typically, not the lawyer, and I think it's important for your employees to understand that you're not their lawyer if you're conducting an internal investigation, that you're representing the firm, whether the firm's a solo firm or a 1,000-lawyer firm. It is really important that you explain to your people, even other lawyers, that you don't represent them, because there is always going to be the courts and the bar are going to always suspect that there's some even unintentional coercion, because if they know you're a lawyer, they can reasonably infer that you are representing them as well, or that you're some sort of expert or definitive voice on the law. So really important to make sure that you put the upjohn warning disclaiming any attorney-client relationship with the individuals in writing if possible. That's really helpful.
So we touched a little bit on, go back for a second, actually. So the last bullet point about the building block, the second building block is sort of having insurance coverage. And that applies across the board, going from professional liability insurance, which every attorney should have, as well as cyber insurance and all the other available products that are out there. But also what is known as, what is known as EPLI insurance, which is Employment Practices Liability Insurance. That is a specific rider under most general liability practices that insures insures the insured on potential complaints by employees into what's the word looking for, into potential complaints about most discrimination matters. Ordinarily, your basic general liability insurance does not actually include this rider, so that's something you should have speak to your broker about, to make sure, or to at least understand the scope of your coverage.
I'll also share EPLI rates for attorneys are typically significantly lower than kind of off-the-shelf rates.
Yeah, and I think the model rules, and obviously your state specific rules will have nuances, but model rules 5.1 and 5.3, really 5.1 mandates that law firm leadership make sure all the lawyers in the firm are being adequately supervised and adhering to the rules of professional conduct. And 5.3 extends that to non-lawyers at the firm. And some states use leadership, supervision, authority, but the basic idea is a senior lawyer is responsible for everyone on the team. And, it's oftentimes, I think, lawyers feel like, oh, I don't have, I'm not the managing partner of the firm, so that's not my problem. But it probably is your problem if someone that you're directly supervising, or even, sort of indirectly supervising, runs afoul, especially a junior lawyer. And junior doesn't have to mean age, right? It's seniority, it's authority within the firm, or even on the matter. So even if you're the more senior attorney by age and experience, but someone else is sort of leading the charge, they could be the supervisory attorney under Rule 5.1 and 5.3. So very important to think about as well. And I think I preach this with all insurance, but I think from the EPLI insurance as well, that, we say risk management policies can reduce premiums. Talk to your insurer. Treat them as a partner. They have as much interest in you being less risky as you do, maybe more, because they're on the hook financially, when problems arise. And this is all your EPL insurer does, right? They just do employment practices liability. They're a great resource. They're going to have a very, very strong risk management resources for you. And, reducing premiums is great, but reducing risk is really the goal. And so, don't be shy about talking to your broker, talking to your carrier, and getting as much information out of them as you can to make your practice safer. It really is just a win-win.
And just to go back a little bit to the earlier point where we said that while ethical risk decreases as firms grow, or the inverse is that ethical or employment liability risk increases as firms grow. So it's an inverse proportion here. One of the considerations here is that most EPLI coverage won't cover you for wage and hour misclassification type matters. So, that while we're focusing really on discrimination here, there's a lot of class action liability when you're dealing with wage and hour. So that's one of the things that as you're setting up your practice grows, your risk also grows exponentially. So you have to ensure from the start that your pay practices are in line with your legal obligation.
And just to be super concrete about this, where we see lawyers and law firms get into risk with misclassification is often on their administrative assistants, their executive assistants, and their paralegals.
Yes.
So,
And from the coverage question, do you see issues come up where partners, either non-equity or equity partners, are considered employees under the insurance or not considered employees under the insurance, or is it really is a toss up depending on
question. I don't know the answer.
Yeah.
Oftentimes you really see lawsuits from more junior staff.
Yeah.
Because there's a lot of issues with overtime and then proper timekeeping. And, if you're billing after hours, you're on your, I'm dating myself, on your BlackBerry after hours, how did you get paid by that time or not?
Yeah. And, I think it probably is like, the non-equity partner, it probably is very fact specific. Like, is this person actually a genuine partner or not? I won't get on my soapbox about using the partner title when someone's not a partner, but it's there. If anybody wants to hear me get on that soapbox, just let me know. So the ethics building blocks, and this is, a non-exhaustive list of the rules that sort of come into play. I talked about 5.1 and 5.3. Oh, and we have a question. Oh, from Stephen. How are you, Stephen?
Stephen.
Are independent contractors considered employees? Any difference if the independent contractor employee is international? So from the ethics and risk management, law firm risk management side, no, right? They're not. There's not a question. I guess I shouldn't say no, they're not considered employees. They're staff. They're under your 5.1 obligations or your 5.3 obligations, whether they're a lawyer or a non-lawyer staff, whether they're a lawyer internationally in their home country and not in the U.S. 5.1 or 5.3 is going to catch them for your obligations, regardless of what the tax law might say or employment law might say. So it doesn't really matter how you classify them as an independent contractor, as a W-2 employee, if you call them partner, if you call them biggest partner ever, none of that actually matters. It comes down to a factual dig into whether they were a supervisor, whether they had the control of the law firm, whether they had the control of the matter. That's it. All of that under 5.1 and 5.3 with a real laser focus on the client that's being impacted.
So just as a footnote, I think I would assume that if you have a genuine independent contract relationship with an external party, you should have some sort of a shifting of risk in those agreements and ensure that, that independent contractor either carries his or her own insurance, or you provide for coverage under your policies for independent contractors.
Yeah, great point. Great point.
I agree with what both of them said. But Stephen, the way that I actually would like to answer your question here is actually two questions. I would reframe. I know. I would reframe this. So the first question, which you haven't really asked, and it kind of alluded to, is this truly an independent contractor or is this a misclassified employee? If it's a misclassified employee, then yes, they are considered employees. And obviously we could talk about individual situations where that might happen. Happens all the time. There are huge task forces, thank you, out there on both the federal and the state level currently, within New York, that are looking for misclassified independent contractors. Second point that I want to make here is, rather than asking the question, are independent contractors employees? The better question to ask might be, what are my obligations to independent contractors? And the reason that I make that distinction is because places like New York have certain obligations to independent contractors. There's a New York Freelancers and Free Act, which talks about
New York City
freelancer agreements. Right. New York and New York City have that. There are also in the discrimination law, which is what we're talking about right now. But in many situations, your independent contractors still have to be trained on anti-discrimination prevention and you are still responsible for your independent contractors potentially discriminating against your employees or your clients. So you still have obligations to and about independent contractors, even if they're not legally employees.
But in terms of the international aspect, I think that gets a little bit more difficult because of how many states, treat the location of employment, and which then dovetails with the question of which law applies to that particular individual. But certainly, regardless, even with an international quote unquote independent contractor or employee, you're might have to be exposed to, even if that international contractor in some foreign country may not be able to sue you for, let's say, wage and hour violations. You might still have discrimination exposure should something happen with that independent contractor.
Really great question. I mean, they covered a lot of ground there, so thank you.
Right. We can write a treatise on this.
Yeah, that's fantastic. Rule 5.4, I think, is so important to remember that, your individual attorneys have to maintain professional independence. And even though they're employee attorneys, the client's rights are paramount. So the client can decide at will to terminate you, to go with your employee who's branching out on their own, which happens in some practice areas way too frequently. And there's very little we can do to prevent lawyers from, there's no non-compete, there's no non-solicitation available. So there's very, very little we can do to protect that attorney-client relationship, because all the power is vested in the client. And then there's
you still have the attorney-client relationship to your prior, allegations to your prior.
Yes, of course, your prior client. But unfortunately, no matter what sort of employment arrangement you try to work out, there's really no way to prevent a lawyer from leaving and taking the client if the client wants to go with that lawyer. There's just, the client has to have that absolute authority to terminate the relationship at will. So I think I see law firms get themselves into trouble by and in New York courts will enforce an attorney non-compete, acknowledging that it violates the rules of professional responsibility, but holding that two attorneys contracting can be bound for that contract. I believe New York's the only state I've come across that will actually even enforce an attorney non-solicitation non-compete. Most states, I think, rationally say, well, this is void as a matter of public policy because it violates our ethics rules. New York has decided to go the other way. And then there's some competing rules. Rule 1.1, the competence, 1.3 diligence, and 1.6 confidentiality. I think all of those sort of push up against the idea of inclusion and anti-discrimination. And if you're trying to adhere to your obligations under Rule 1.1 and 1.3, the answer is always to pick the most senior attorney you have, the most competent attorney you have. And I think oftentimes law firms want to let newer attorneys take on more and more responsibility to learn and grow. And it's often good to do that on the client's dime. But at the same time, there's this sort of competing obligation where you want to make sure you're giving opportunities out equally, or at least equitably. There's this competing ethical obligation to make sure that you're protecting the client 100%. So even in, as you discussed, the well-intentioned policies to sort of bring other lawyers and staff into different matters and to diversify, I think there's still a lot of risk there in that you're bound by these obligations and have to keep that paramount. So, all right. So here, for your enjoyment, is the full text of Rule 1.1, 1.3, 1.6, 5.3, and 5.2. And we're going to periodically invite questions if anybody has any other questions. Stephen, you struck gold with that first one, so if you have something else.
I'll also say, if maybe to keep this interactive, even if you don't have a question, if you want to share in the chat, out of all of the tips and tricks that we've kind of brought up here, what's the most interesting to you or something that you might consider bringing back to your law firm?
We're going to have a question and a question answer period toward the end. If you can, if you think of something later.
Yes.
No pressure.
No pressure.
A little pressure, just a little pressure.
Just a little. Stone's responding. Okay. Let's talk about confidentiality and social media use.
Favorite topic, John.
Yes.
Jeff loves
this slide from Bill Lauer, which is a different presentation.
Oh, different.
Great. From the employment law perspective, the areas of protections and the rights that you have as an employer over your employees maintaining confidentiality and not sharing things on social media use is actually a really interesting landscape. And I would say it's continuing to change, but it actually hasn't changed all that much in a while. What is changing is the strength of the NLRB. So let's talk for a second. Generally, of course, employers, including law firms, are allowed to ensure that their employees are maintaining certain things confidentially and are not sharing stuff on social media. Obviously, things that are illegal, things that violate another person or the firm's intellectual property, client confidences. Of course, they can protect that stuff. What happens though often is that it's not just law firms; it's all employers will draft these confidentiality provisions in their handbooks or in agreements with their employees that end up having a chilling effect on employees' lawful rights to exercise certain kinds of speech that are unrelated to business objectives. And so what does that often look like? Employers coming down on employees, talking about political affiliations, things in the news, right, being on one side or the other of the political spectrum, wanting to come down on employees who complain about things going on in the workplace. Employees do have rights under both lawful off-duty conduct laws that are in effect in numerous states to engage in certain kinds of political speech. And they also have rights to form unions or engage in speech which could form a union. All of this kind of this last kind of speech is typically known as concerted activity. So an employee reaching out on social media and saying like, gosh, my manager constantly underpays me. I wish we could get together with a whole bunch of other lawyers and do something about it, is very arguably concerted activity. And if you, as the manager of the law firm, wanted to take disciplinary action against that employee, you would be running a risk there of violating their rights to engage in concerted activity. Protection of, as I mentioned, the protection of trade secrets and client confidences, that's usually going to pass muster. The point is you'll want to make sure that your confidentiality rules and application of those rules is being applied evenly across the board. We have seen an uptick, I would say, in the last couple of years with certain events, particularly in the Middle East, certain events on the home front with Donald Trump's election, that employers sometimes, including law firms, they might want to position their firm leaning in a certain way on certain ones of these issues, and then only disciplining employees who are speaking in kind of the opposite way. And we have seen lawsuits that haven't necessarily reached a conclusion yet, but we have seen lawsuits arise over disparate treatment of employees engaging in what they consider to be protected social media use and disparate applications of those that they're alleging are then related to protected characteristics such as race or national origin.
And I think the employment, I think this is probably the most tension between employment law and our ethics rules, because the ethics rules really go the other way. And we talked about 5.1 and 5.3 and our obligations to monitor our employees, whether they're lawyers or not. Social media use is key, and you have to, not doing it is not an option. You can't just assume people are using their social media responsibly. I would say assume they're not. And I think I have two rules, but, rule 7.1 and the other advertising rules, obviously every single post that anyone who works for you makes on social media could be construed as advertising. And in the same way, you have to look at every single post. I post on LinkedIn 3 times a day at least. And I try to think about this. And I see we do have a long question, so I'll keep talking, and it says NLRB, so it's not for me. Every single post could be a Rule 1.4 client communication. And then I see law firms get in trouble a lot with 1.6 confidentiality, where a junior lawyer or staff member is saying things that maybe are anonymized enough. They're not naming the client, but, if you will go on the docket and you search, the 200 cases this law firm has, you can figure out who they're talking about. And if the client hasn't consented or, you haven't even asked whether your paralegal can post about the case in a very abstract way, that's going to be a problem. That's going to be a real problem. The other big concern is, junior attorneys, even senior attorneys, sort of commenting outside of their depth, right? We all feel comfortable commenting on, international geopolitical issues and you know, constitutional right. I'm not a constitutional lawyer. I don't know anything about geopolitical issues. I defend lawyers. And so I am much more likely to comment on something I have no business commenting on because it's like interstate or whatever, you know, about the First Amendment. And if you're a lawyer and you're commenting about the First Amendment, you know, people can't look at that and say, well, this guy's a lawyer. And especially if a client follows you on social media or sees your post, they could arguably reasonably rely on that point. So you want to really think about that as well. I see we have some questions. I guess you want me to read? I'll read the first one.
Yeah, sure.
In NLRB Protections for Employee Speech on Working Conditions, are panelists familiar with the case of the Russian-American lawyer who, after separating from, so a little cut off, her firm, launched an Apple podcast sharing insider details about abusive management and partners, leading to a lawsuit from the firm? Do you have stats on how often law firms go after former employees for airing dirty laundry? And then
I believe the Russian lawyer was sued in Texas federal court, and the firm's attorneys tried to get injunctions to stop her from posting a podcast.
Well, that's fascinating. I had not heard about that. You've given me some homework to do. So happy to look that up. And I guess what I'm gonna say off of that. Speaking of commenting on things I don't have. Right.
we're asking a question. Nice.
It's very possible that the content of what's in this Russian-American lawyers podcasts go beyond the realm of concerted activity. It's very unlikely that a person, I'm just going to say this, right? It's very unlikely that a person starting a podcast is really trying to engage in concerted activity, especially as a former employee. Because what is she trying to do in that situation? How is she trying to change the culture? Is it concerted activity? Is it just complaints? Also, is she disparaging the firm unlawfully? Is she defaming them? Just because she's going on and talking about her experience doesn't mean her experience is true or what she believed. You know, people who go on podcasts might be entertainers. And I'm not saying she is. Maybe she's being completely accurate and the law firm is being a bully. I don't know. I don't know the situation. But what I'm saying is that law firms should not consider themselves completely powerless if someone is going on social media and doing bad things. She also might have had a contract that they went out the door and she agreed to keep quiet about certain things, or maybe they resolved the case. I don't know. The point is, be aware of these obligations, and know that there's certain times where you can discipline employees for engaging in unacceptable social media use, and sometimes there are things that you can't go after and you can't hold the employee against. One thing that Jeff mentioned also, and it's very common in handbooks and in policies, most of the handbooks that I write do have social media policies. They have computer use policies, things like that. We'll always put a line in that says, if you're doing posts on social media, they should be, you should represent that they're your own views and not the views of the firm. And that's, again, another way of showing that you have a policy and practice in place of trying to prevent exactly against the risk that Jeff just identified.
And very, very timely. New York's first department actually just issued a decision, and I used my social media, that's my LinkedIn page, to find where I posted about it. And it sort of controverts ABA Formal Opinion 496. 496 says that lawyers shouldn't really respond to online criticism.
Actually, maybe we should move on to that next slide. Maybe we should do that.
Sure.
Because that would actually.
Yeah, the social media policy.
I see.
There you go. There's the rule in its glory. And so the case is actually Salskowitz versus Liu. And the first department decided that, we could actually respond to online criticism. There were pretty extreme facts in that case. The dissatisfied client in this case took out a jeffcunningham.com basically domain in the lawyer's name to just trash the lawyer. And so the lawyer was allowed to respond. But I think it's important to remember that even a former employee who is trashing the firm, you have to be particularly careful from an ethics standpoint that you're still protecting the client, right? And you don't want to say, this employee was just a terrible employee. They screwed up everything they touched, because all your clients are going to look at that and say, well, did they work out as if they?
I see that invoice, but that
exactly. You charged me charge me for all that terrible work. So,
Yeah.
and then Rule 1.4 and then 8.4G, I think is really important to talk about. All social media communication is in fact communication. 8.4G, adopted by a little over half of the jurisdictions, and of course every state has sort of tweaked it a bit, but 8.4G really prohibits lawyers from engaging in any kind of harassment, discrimination. And so I think it's really important that, and it's so far it's sort of held up to First Amendment challenges that like
Not Pennsylvania, right?
so yeah, Pennsylvania, a couple of states have like backtracked, but you have to know where your state stands on 8.4G. And if you're using social media, and you happen to be sitting comfortably in Texas, I don't think Texas has 8.4G. They might have something buried in another rule. If you're in some state that doesn't have 8.4G, but you're talking, right, you're posting and such in an area that does, then I think it's important that you keep that in mind as well, that, you potentially could be exposing yourself to any harassment or discrimination. And the rule itself has the protected classes and things like that. And again, AVA formal opinion 480 sort of goes the other way from New York's recent case that says, we can't engage clients, strangers, crazy people on the internet, former employees, in any way that could, negatively impact the client. So you really want to think about that. And I think the bottom line is you have to have a social media use policy where you tell your people how they can and can't use social media, and you have to monitor it. You have to enforce it. You have to really see how your people are using social media. And, just assuming your employees are not on TikTok is not acceptable. You have to find out, like, are they on TikTok? Are they communicating with clients on TikTok? Are they advertising inadvertently? Is a paralegal or an assistant or some other non-lawyer potentially holding themselves out as a lawyer of sorts because they work at a law firm? Things like that are always a problem.
Right. Fortunately, just before we answer that, I think a lot of these, we see a lot of these extremes about, this story that was like in the comment, or this case out of the First Department. There's really extreme examples, but on a day-to-day basis, you just have to be mindful of how your employees are engaging with social media and not just assume that they're engaging in a common sense way. Because there are extreme cases and they're very fact specific. And for example, this case that the First Department was really about, defamation and then torsion, I think it was torsion feared stuff.
Yeah.
And I'm sure something in the Texas matter, which we'll look into. I'm really curious about that.
Yeah.
I'm sure there are, the nuances of that case are not, are definitely define why, at least in that particular instance, the firm chose to go after the attorney and what the defenses are.
And then our question is on the social media theme: what are common social media policy mistakes that create ethical or employment law exposures for law firms? You want to take the employment first? You want me to talk about
on the employment law side? I would say probably not having the social media policy is typically the biggest risk there. And what that does when you don't have policies on things is it leads to inconsistent enforcement. But I think two big things to be concerned about is, again, being familiar with the lawful off-duty conduct law in your state. Again, in New York, there's a very specific lawful off-duty conduct law, which talks about certain kinds of political acts and making sure that
that defined within, it's not all, it's
not all
defined.
No, there are defined, but you want to make sure you're obviously not taking adverse action against employees that for something that's specifically defined in the way that they're allowed to speak. And the other one, at least at a kind of a first very high level pass, would be anything that would reasonably chill concerted protected activity. And what the general counsel for the NLRB, would they issue guidance on this periodically. The standard keeps changing, whether it's like the reasonable employee or, where we are right now is probably more employer friendly. But they'll look for confidentiality policies or social media policies that are not tailored to protect legitimate, protectable business interests.
Yeah, I think so. You hit the nail on the head for the ethics side too, like not having a policy, or then having a policy that's meaninglessly broad, like you can't use social media. I mean, that's, you're almost better off not having a policy if that's what you're going to try to do. I also think a big mistake in social media use policies that can create ethics, risk management, exposure for law firms is not having a clearly defined avenue. Like, you should be talking to the chief marketing officer if you have questions about your social media use. You should be talking to our general counsel. You should be talking to your supervising attorney. Some avenue for, your people are using social media. And so helping them do it in a safe and productive way, I think, is absolutely key from an after-action risk management standpoint. When you're trying to explain to the bar, this paralegal did sort of use some information that did expose our client, but it's all publicly filed. They followed our social media use policy, which we trained them on, which we had employment counsel look at, which we had ethics counsel look at. It makes a much more defensible situation than if you have some kind of silly ban on social media use or something like that. So I think that having those clear avenues where people can get the resources they need is key.
Yeah. And you've actually just reminded me something too of a very common policy, which I always encourage people to have too, is if the press comes and asks you a question, right, there's only certain people who can speak on behalf of the firm, right? That's not preventing them from speaking, but it's saying that if they're going to be they shouldn't be representing themselves as the people who can speak on behalf of the firm. They should know who to do that with. Another social media policy, which is not exactly in what we were talking about, but no fee, having a policy that says there's no obligation to accept friend requests from either your colleagues or your clients or something like that, can also be really protective against sexual harassment claims.
That's a great point. How can lawyers balance confidentiality obligations with legitimate business needs when employees use social media? I'm going to answer first and say there is no balance. Client confidentiality comes first and foremost, and your employees' rights, go out the window. Now, I know that's not true, right? But 1.6 is absolutely sacrosanct. And if it's client confidentiality, not the law firm's own
confidentiality and money, those are the worst. Yeah, exactly.
Yeah. And then I'll defer to I guess more of the right answer. But really, you want to demonstrate that your client confidentiality is the absolute, foundation that your law firm is created on. And everything else is sort of after the fact.
Why don't we move on to, I think there might be some more questions here, but I think we can...
I see a very question about, that's a very interesting question about the person at your firm using foreign-based managers.
Yeah, we want to save that to the Q&A.
Yeah, definitely. That's a president.
Okay. All right, so substance abuse, mental health, and disability claims. Again, attorney wellness is risk management. And in our statistics, when it comes to anxiety and depression, substance abuse, drinking and alcohol, and suicidal ideation are about 3 times worse than the average American. I think there's a whole host of reasons for that. And there's lots of resources that are being put out by the bar associations. It's not enough to say, here, go talk to the bar. You have a drinking problem or a gambling problem or something like that. Law firms are really uniquely placed to help their people, better than a regular business, I think, better than a family member, I think. I really think that you are in the best possible place to help your people before their problem spirals out of control. And more importantly, from my perspective, before their problem spirals out of control, ruining their life, and by extension, your life and your law firm's existence. And it happens. I mean, anecdotally, 55% of all from the ABA, 55% of all legal malpractice and ethics complaints involve attorney wellness, either mental health and or substance abuse. Anecdotally, I found that number to be much closer to 100%. That, if there's a meritorious claim for legal mal or actual merit to the grievance, I get a lot of frivolous ones, but if there's a real stuff going on, there's definitely attorney wellness in it. I mean, 100% of the time for me, there's some underlying issue that's mental health, substance abuse, gambling, all three. It's always there. And so I think it's really, really important that law firms address this, not just from it's the right thing to do, help your people out, but purely from a self-preservation standpoint. It's so important.
And just this is an old study that we quoted. That's the most sort of on point and official numbers that we can find. It was an ABA partnering with the Hazelden Betty Ford Foundation, and this is going back to 2016. And since then, we've seen a rise. First of all, COVID was a big issue, obviously. Then with the rise in remote work, and I'm sure some of that attorney isolation of attorneys are working solo practice, working from their home or their remote office. They don't see anybody. They don't have the support, or they feel they can't get support. And so,
yeah, I will also share, right, among our, among the law firm clientele that we see in our practice, the number of mental health requests for accommodations in the last couple of years has skyrocketed. And I think we've seen a lot more requests for accommodation for attorneys suffering from ADHD, anxiety, and depression. And there has been absolutely a marked shift in the last couple of years with those kinds of things, arising in the legal profession and in other places as well, but particularly among lawyers. So I think, our whole industry is one that is very stressful. It requires a lot of independence. It is constant judgment, and it's built on imagining the worst. Right? Anxious minds are almost built for being lawyers.
Right.
So
Yeah, it sort of goes hand in hand.
Can we quickly touch on?
yes,
Yeah.
sure. So, if you were just listening to what Jeff said, you might be tempted to say, I don't want anyone with any mental health problems or substance abuse being in my firm at all. It's too much of an ethical risk to my clients. Unfortunately, if you did that, you would be running afoul pretty much immediately of a host of labor and employment laws, which do govern and require you to handle those situations rather than not handle them and separate your people. So you've got the Americans with Disabilities Act, you've got state disability laws. Not even listed on here. You also have the Family Medical and Leave Act, and you have state and local versions of cognates of the FMLA as well, and certain kinds of paid family leave and things like that. When it comes to any of these ADA state disability leave laws, not all substance abuse, illegal substance abuse mostly on the job, not protected, but someone who is undergoing treatment for substance abuse, someone who has alcoholism or addiction as a disability, or they're self-medicating to treat a mental health problem, these are all become intertwined. And you will have obligations as an employer to both typically you might have obligations to provide leave if necessary. You for sure have obligations to engage in an interactive process. That's just a fancy word for a conversation that actually lays out what the employee can do, can't do, in ways that don't get into the employee's health conditions and diagnoses and prognoses, trying to really figure out what the employee can do. And you have obligations to come up with and document a reasonable accommodation and enforce it if one can be found. Again, sometimes the interactive dialogue leads to the inevitable conclusion that there is no reasonable accommodation, but failure to have that dialogue, particularly in a state like New York City, or a city like New York City, can be itself a violation of the law simply from failing to have that conversation, even if no accommodation could be reached. So very important to have that conversation, even under national law, federal law, and see what is available for accommodating employees.
Jeff, you want to touch on sort of the ethical rules that affect? So we can.
I'll touch on this just one more second. So New York, for instance, also has just one thing that also complicates this, has part of their legal off-duty conduct law, which we just talked about for political speech, also has guidance on has specific rules for cannabis use. So lawful off-duty cannabis use is not necessarily something you can terminate your employees for. And there's specific guidance that says, just simply smelling cannabis on a person at work would not be sufficient to, discriminate against them. So try to distinguish.
Yeah, and then on the other side of that, I guess just smelling cannabis on a lawyer or staff member could very well be raise your 5.1 obligations to say, is this person impaired? Whether it's alcohol, whether it's someone falling asleep at their desk, or, there's so many warning signs, so many concerning behaviors that are completely protected by employment law.
If you see signs of impairment, you absolutely can discipline someone for that. Say smell alone isn't. So,
right.
Yeah.
So yeah,
justify.
Under 501, that might still trigger the obligation.
Right. It might.
Yes.
Exactly. Yeah. To dig into it, to remove that lawyer or staff member from certain cases or all their caseload, and then certainly to engage, employment counsel and go from there. We've got a bunch of case studies that I think we'll probably skip at this point. Happy to talk through them. We had great questions, and I do want to answer this other question at the end. So let me skip past our case studies. And there's some more of the rules. Any other questions?
And if anyone wants to reach out to us individually, obviously we're always happy to answer questions. And, we'd love to meet all of you.
And then I do want to just focus everyone on our disclaimer, that this is not legal advice. There's no attorney-client relationship formed. We do appreciate everybody joining us. Any other questions? Please let us know. And yeah, let's, this last one, I see a lot of personal injury firms scaling by using foreign-based case managers in Latin America who join as independent contractors and work 100% remotely. How can these firms safeguard information, confidentiality of client case info, et cetera? Great question. And I also see a lot of law firms using it and using foreign lawyers, right? They're lawyers in their host country, in their home country, and they're able to work as paralegals, case managers, whatever, with the, and it's not just in the personal injury space, but I admittingly see it in the personal injury space as well. And I think the reality is you can't, right? You can't ensure that, the confidential information you're sharing with someone overseas is protected, just like you can't if you let someone have access to your office, a staff member have access to your office, or if someone's working remotely from across the street. Now, the person who has access to your office or across the street is within the jurisdiction of your state and the U.S., and it's much easier if they do something nefarious. I think, and this is not something I think most of these scaling personal injury firms do, but I think by cleansing the data of confidential information, right? You don't have to give the social security number to that case manager. You can assign a client matter number like most law firms do, that on the back end connects to the date of birth, the social, the private information that you don't want to spread around the world. It's another step, and that's why I think a lot of firms aren't doing it. The reality is I think a lot of firms aren't concerned about it. They're just expecting, that especially a lawyer in another country will be held to the same standard. I think that's extremely dangerous, but I just sort of get it. And I don't know if I'm an employment size.
So maybe this is also a separate discussion, obviously, but cyber risk plays a big role in this. I mean, even if that attorney in, let's say, Argentina is not actively engaging in stealing clients' data, there's a lot of different steps in between where there could be an intrusion and a
Definitely.
So I was going to say, right, some physical controls too, to make sure that all employees, or maybe even independent contractors in this case, are using tools that can either be remotely wiped or remotely locked, right? So requiring your Latin American attorneys, or wherever probably all your attorneys, honestly, to log into a portal, or what is that called? Like a Citrix situation. That way, as soon as I know Citrix doesn't exist, but that kind of a thing, so that if, God forbid, their laptop gets stolen, their smartphone gets stolen, whatever it is, or they're just terminated from the firm, right? You as the employer have control over their ability to get into those documents and can prevent it. So those kinds of things could be very, very important.
Also really helpful for domestic attorneys and staff who are traveling, especially, these days, coming back into the U.S. border, although, also going to certain countries or many countries. That's a real concern with attorneys and staff traveling with devices. We've seen an increase in attorneys, especially immigration attorneys, being targeted upon re-entry and having their devices taken. So, having those protections, those physical protections built in place is really key.
Right. And didn't you mention getting rid of the facial recognition?
Yeah, the Face ID. Like if Homeland Security takes you and they take your device, they can hold your device up to your face, and
So I think that search and seizure rule though has existed for a long time. Yeah, 100 miles around. I'm dating myself. Constitutional law, 1L class, but I think it was like 100 mile radius where the search and seizure rules are different than elsewhere.
Yeah, I'm hearing of it being much more active,
right,
against attorneys specifically, which is kind of new. And any other questions? Feel free to drop in the chat or to email us here. And thanks so much for joining us.
I did also want to thank everyone for joining us today, as well as our lovely speakers for an absolutely fascinating presentation. It was really informative, and thank you so much for sharing your knowledge with all of us and answering those questions and providing us such an engaging presentation. We really, really, truly appreciate our speakers and everyone who has joined us for today. Now, I did also want to... Thank you. Thank you. I did also want to remind everyone, as I did at the top of the presentation, of the services available to you through our website platform, Justia Elevate, our innovative feature-packed website solution designed specifically for law firms. Built on a powerful WordPress platform, Justia Elevate offers tools like the Justia AI Writer, which is designed to help you create effortless content for your website, the AI-powered Justia Chat to enhance your leads, and FAQs for AI to help you better your chances of showing up for those AI results. You'll have everything you need to stand out online, with plans starting at just $82.50 per month when paid annually. Once again, you can check your pricing at elevate.justia.com/price. I hope everyone has a wonderful rest of your day. Thank you so much.
Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.